Good evening, friends. This is the fifth video on law of evidence. In this video, we will be seeing one of the basic terms, that is evidence. We will continue with section 3 of Indian Evidence Act, where the interpretation of various terms have been laid down. A bare reading of the provision of the Act states that evidence means and includes all statements which the court permits or requires to be made before it by witnesses. So, all statements made by witnesses in relation to matter of fact under inquiry, such statements are called oral evidence. So one thing which the Bare Act states is that evidence means and includes oral evidence. Second, it says all documents, including electronic records, produced for the inspection of court, such documents are called documentary evidence. So evidence means and includes oral evidence as well as documentary evidence. Electronic records are also included in it. My dear friends, please remember that many a times they have asked whether electronic record is a type of evidence. Then as per section 3, it is a type of documentary evidence. Now, we will just have a brief overview of what all we are going to discuss in this video. First, we will discuss what is meant by term evidence. Thereafter, we will see the various types of evidences. Then, we will also critically analyze the definition of evidence as it is given under Section 3 of Indian Evidence Act. Thereafter, we will also look at the appreciation of evidence and also the juristic conception of the term evidence. Friends, many a times in examination, short notes are asked on the term evidence. Now, in that short note, it is to be remembered that it has to cover all the dimensions as has been mentioned in these 5 points. Now, one by one, we will take it up. First thing is, what is evidence? The word evidence has got a Latin origin, and it has originated from the word evidere, which means to show clearly, to discover clearly, to ascertain, to prove. So the word evidence means literally to show clearly, to discover clearly, to ascertain, to prove. Now, the definition of the term evidence has been given by famous English philosopher, jurist, and social reformer Jeremy Bentham. He has said that evidence means any matter of fact, the effect, tendency, or design of which is to produce in mind a persuasion, affirmative or disaffirmative, of the evidence of some matter of fact. In brief, evidence means anything by which alleged matter is either established or dismissed. That is, anything which creates in mind or which has a tendency of creating in mind a persuasion about existence, non-existence, affirmative or non-affirmative of some matter of fact. So anything, evidence means anything by which alleged matter is either established or dismissed. For example, if we say that if the question is that whether before an explosion, fire, whether before a fire, explosion occurred or not. That is, first of all there was explosion and then there was fire. Now the question is that whether explosion took place or not before fire. Then the evidence to prove that explosion took place would be noise of the explosion, flash of the explosion. So if these two things were observed by some person or through some CCTV camera, then we can infer that yes, explosion took place before fire. So the basic meaning of term evidence is that anything by which alleged matter is established or dismissed. Now, classification of term evidence or various types of evidences. Friends, evidence has been broadly classified into five groups. I am saying five groups because they are in form of twins. The first group is that of direct evidence and circumstantial evidence. Direct evidence are those which are sensed by the person who has actually seen, heard, or sensed the commission of act, including the original document. So, direct evidence means two things. One, it means either the original document or the evidence of the person who has sensed the commission of the act. Then, circumstantial evidence. Circumstantial evidence is opposed to the direct evidence. Here there is direct perception, while here there is indirect inference. From the surrounding circumstances, a definitive inference can be drawn, then that will be a circumstantial evidence. Another is real evidence and hearsay evidence. Now, hearsay evidence are those which are derivative, the second hand. They are things which have been heard, things which have been told by some other person. But the person who is stating it has not directly seen it, has not directly heard it, but he has heard it, he has received the knowledge from some other person. While in real evidence, it is any matter which the court perceives itself. That will be a real evidence. Next is primary evidence and secondary evidence. Now, these are used in the when we see the documentary evidence, then the term primary evidence and secondary evidence comes up. Primary evidence are the original document itself, while secondary evidence are the copies of the original documents which are admissible in court of law. Then we have got another classification of evidence as positive evidence and negative evidence. Positive evidence are those which proves existence of a fact. It is affirmative in nature. While negative evidence are those which proves non-existence of a fact, that is, they are negative in nature. Then another classification is oral evidence and documentary evidence. Now, this is the classification which has also been given under Section 3 of the Indian Evidence Act, which states that oral evidence are the statements made before court by witnesses, while the documentary evidence are documents produced before court for its inspection. So these are the five classifications or broad classifications of the evidence: direct evidence and circumstantial evidence, real evidence and hearsay evidence, primary evidence and secondary evidence, positive evidence and negative evidence, oral evidence or documentary evidence. Now, we will critically analyze the definition of evidence as it is given under Section 3 of the Indian Evidence Act. Friends, as we have already seen that Indian Evidence Act Section 3 states that evidence means and includes. Now, this word means and include is the first point of our critical analysis. And this has been laid down in Hardeep Singh versus State of Punjab. That wherever the term is means and include, it means it is an exhaustive definition. Exhaustive definition means that it is hard and fast definition. No other meaning can be assigned to it other than the expression that is laid down. So, as far as the word evidence as included in the section 3 of Indian evidence is concerned, it is exhaustive in nature. Exhaustive, why? Because the word is means and includes. So if it is means and includes, it means that it is hard and fast definition. It is limited in nature. Next is that it is incomplete definition, and that has been laid down in famous case of K.K. Veluswamy versus N. Palanisamy. Why is it incomplete? Why is it called that the definition given under section 3 is incomplete? Well, friends, it is incomplete because it does not include the whole of the material on which decision of judge may rest. For example, whenever a judgment is given, then this definition does not include everything on which the decision is made, because there are certain other media of proof rather than oral and documentary evidence as mentioned under section 3. For example, the result of local inquiry, the facts which the court takes judicial notice of, the demeanor, that is the outward behavior of the witnesses in the court. So these things are also taken into account besides the evidence, oral and documentary, while the judgment is made. So, as these things are not included in the definition of the evidence under section 3, therefore it has been held to be incomplete. Then, third point in it which we can write is that it includes two types of evidence: statement of witnesses, which are oral evidence, and documents produced for inspection of court, which are documentary evidence. And one very important aspect is that every kind of evidence, whatever kind of evidence is produced in court, can ultimately be reduced to the either category. So if we critically analyze the term evidence, then there are three things which comes up. One, it is exhaustive in nature because the word means and include is there. Second, it is incomplete because it only mentions about oral evidence and documentary evidence and does not deals up with other things on which judgment is made. For example, result of local inquiry, the manure, then judicial notices. And third is that it includes two kinds of evidence: statement of witnesses and documents. But all kind of evidence can ultimately be reduced to either of these two categories. Next is appreciation of evidence. Now, appreciation of evidence means the reliability quotient. How much reliance can we put on the evidence which is produced before the court? How much the court can believe on it. Now, there are two factors which define the appreciation of evidence or reliability quotient. One is the consistency, that is it consistent or is the evidence given is inconsistent. And another is the probability, that what is the probability of its occurring or what is the probability of its non-occurring. For example, if a person is said to be at a scene of crime and at the same time he is stated to be at some other place than the scene of crime, then there is impossibility involved in it because a person cannot be present at two places at the same point of time. So, consistency and probability of evidence defines its reliability quotient. And my dear friends, it is very important and very difficult function, and that is why in famous case of Ganesh K. Gulve versus the state of Maharashtra, it was stated that it is the function of separating grain from chaff. So appreciation of evidence deals with the reliability quotient and depends upon the consistency and the probability of the evidence. Next is the juristic conception of term evidence. strength, the juristic conception of term evidence is that evidence against a party can only be used when the other party against whom it is to be used has the right as well as the opportunity to cross examine the source of the evidence. So, if it is a oral testimony, the right of cross examination of the witnesses. If it is document, then the right to cross examination on the basis of the document. So, a evidence can only be admitted when it the other party against whom it is to be used has the right and the opportunity to cross examine. In famous case of Vidyadhar versus Manik Rao, it was stated that if a party to a suit does not offer himself for cross-examination, that is, if an evidence has been provided by a party, but that party which has provided the evidence or that witness who has stated something is not subject to cross-examination, then a presumption would arise that case set up by him is not correct. So until and unless these statements are cross-examined, we cannot rely on it. So juristic conception of term evidence implies that the party against whom it is to be used has the right and opportunity to cross-examination. This is the whole about the word evidence as we have seen, and we will give a quick recap to what all we did in this video. We first of all went through the Bayer Act provision where it states that evidence means and includes the oral evidence and the documentary evidence, including electronic records. Then we saw that evidence means to show clearly, to discover clearly, to ascertain, to prove. It has got a Latin origin from the word evidere. Famous definition has been provided by Jeremy Bentham, where it states that anything which has a tendency to create in mind a persuasion as to existence or non-existence of some other matter of fact. That is, in simple terms, evidence means anything by which alleged matter is either established or dismissed. Now, there are various types of evidence, and it has been grouped into 5 main groups. These are called 5 twins. One is direct evidence and circumstantial evidence. Another is direct evidence are those which are produced by the person who has actually sensed it, including the original document, while circumstantial evidence are evidences from surrounding circumstances. Real evidence and hearsay evidence, these are matters which court perceives itself, while hearsay evidence are those which are second-hand evidence. Primary evidence and secondary evidence, primary are those which are the original document itself, while secondary are the admissible copies. Positive and negative evidence, positive are those which proves the existence of fact, while negative are those which proves non-existence of a fact. Oral evidence and documentary evidence, oral are those which consist of statements made before the court, while documentary are those which consist of the documents produced for inspection of court. Critical analysis of definition of evidence as given under Section 3 of Indian Evidence Act is that it is exhaustive definition as has been laid down in Hardeep Singh versus State of Punjab. It is incomplete as has been laid down under K.K. Veluswamy versus N. Palaniswamy because there are other factors also on which decision may rest. Then it includes 2 kinds of evidences and every other kind of evidence can ultimately be reduced to the either category. Then as far as appreciation of evidence is concerned, it means reliability quotient and it consists on the consistency and it depends upon the consistency and the probability of the evidence given. The juristic conception of term evidence is that the party against whom it has to be used had the right and opportunity to cross examination. And in Vidyadhar versus Manik Rao, it has been said that until and unless the party offers himself for cross examination, a presumption would arise that the case set up by him is not correct. Thank you, friends.